Good evening, sir. My name is Daniela B. Paglinawan from Section D. So the first question in our final examination are 1. Who must prosecute criminal action under the latest amendments to Section 5, Rule 110? All criminal action commenced by a complaint or information shall be prosecuted under the direction and control of the prosecutor. 2. When is a complaint or information deemed sufficient? A complaint or information is sufficient if it states the name of the accused, the designation of the offense given by the statute, the acts or omission complained of as constituting the offense, the name of the offended party, the approximate date of the commission of the offense, and the place where the offense was committed. When an offense is committed by more than one person, all of them shall be included in the complaint or information. Number 3. What are the elements of prejudicial question? The elements of prejudicial questions are A. The previously instituted civil action involves an issue similar or intimately related to the issue raised in a subsequent criminal action, and B. The resolution of such issue determines whether or not the criminal action may proceed. Number 4. Define preliminary investigation when it is required. Preliminary investigation is an inquiry or proceeding to determine whether there is a sufficient ground to engender or well-founded belief that the crime has been committed and the respondent is probably guilty thereof and should be held for trial. Number 5. What is inquest investigation? When a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the complaint or information may be filed by the prosecutor without need of such investigation provided an inquest has been conducted in accordance with existing rules. Number 6. Define arrest. How is it made? Arrest is taking of a person into custody in order that he may be bound to answer for the commission of an offense. An arrest is made by an actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest. Number 7. What are the instances when arrest without a warrant is lawful? Arrest without a warrant when lawful. A peace officer or a private person may, without a warrant, arrest a person when in his presence the person to be arrested has committed, it's actually committing or it's attempting to commit an offense. When an offense has just been committed and he has probable cause to believe based on personal knowledge of facts or circumstances that the person to be arrested has committed it. And when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. Number 8. What is bail? What are the kinds of bail? Bail is a security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court is required under the condition hereinafter specified. Bail may be given in the form of corporate surety, property bond, cash deposit, or recognizance. All kinds of bail are subject to following condition. A. The undertaking shall be effected upon approval and unless cancelled shall remain in force at all stages of the case until promulgation of the judgment of the regional trial court irrespective of whether the case was originally filed in or appealed to it. B. The accused shall appeal before the proper court whenever required by the court of these rules. C. The failure of the accused to appear at the trial without justification and despite due notice shall be deemed a waiver of his right to be present thereat. In such a case, the trial may proceed in absentia, and D. A bondsman shall surrender the accused to the court for execution of the final judgment. 9. Give 5 rights of the accused. In all criminal prosecution, the accused shall be entitled to the following rights. A. To be presumed innocent until the contrary is proved beyond reasonable doubt. B. To be informed of the nature of the cause of the accusation against him. C. To be present and defend in person and by counsel at every stage of the proceeding, from arraignment to promulgation of the judgment. The accused may, however, waive his presence at the trial pursuant to the stipulations set forth in his bail, unless his presence is specifically ordered by the court for the purposes of identification. D. To testify as a witness in his own behalf but subject to cross-examination on the matters covered by direct examination. His silence shall not in any manner prejudice him. E. To be exempt from being compelled to be a witness against himself. Number 10. How is arraignment made? The accused must be arraigned before the court where the complaint or information was filed or assigned for trial. The accused must be present at the arraignment and must personally enter his plea. When the accused refuses to plead or makes a additional plea, a plea of not guilty shall be entered from him. When the accused pleads guilty but presents exculpatory evidence, his plea shall be deemed withdrawn and a plea of not guilty shall be entered for him. Number 11. What is plea bargaining? Plea of guilty to a lesser offense. At arraignment, the accused, with the consent of the offended party and the prosecutor, may be allowed by the trial court and plead guilty to a lesser offense, which is necessarily included in the offense charge. After arraignment but before trial, the accused may still be allowed to plead guilty to said lesser offense after withdrawing his plea of not guilty. No amendment of the complaint or information is necessary. Number 12. What are the instances when arraignment may be suspended? Upon motion by the proper party, the arraignment shall be suspended in the following cases. A. The accused appears to be suffering from an unsound mental condition which effectively renders him unable to fully understand the charge against him and to plead intelligently thereto. In such case, the court shall order his mental examination and, if necessary, his confinement of such purpose. B. There exists a prejudicial question, and C. A petition for review of the resolution of the prosecutor is pending at either the Department of Justice or the Office of the President, provided that the period of suspension shall not exceed 60 days counted from the filing of the petition of the reviewing office. 13. When does the double jeopardy attach? When an accused has been convicted or acquitted, or the case against him dismissed or otherwise terminated without his express consent by a court of a competent jurisdiction upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused had plead to the charge, the conviction or acquittal of the accused or the dismissal of the case shall be barred to another prosecution for the offense charge or for any attempt to commit the same frustration thereof or for any offense which necessarily includes or necessarily included in the offense charged in the former complaint or information. 14. What is the order of trial in criminal cases? Order of trial. The trial shall proceed in the following order. The prosecution shall present evidence to prove the charge in the proper case the civil liability. B. The accused may present evidence to prove his defense and damages, if any, arising from the issuance of provisional remedy in the case. C. The prosecution and the defense may, in that order, present rebuttal and surrebuttal and evidence unless the court, in furtherance of justice, permits them to present additional evidence bearing upon the main issue. D. Upon admission of the evidence of the parties, the case shall be deemed submitted for decision unless the court directs them to argue orally or to submit written memoranda. E. When the accused admits that the act or omission charged on the complaint or information but interposed the lawful defense, the order trial may be modified. Number 15. When can co-accused be discharged to become a state witness? Discharge of accused to be a state witness when two or more persons are jointly charged with the commission of any offense. Upon the motion of prosecution before resting in its case, the court may direct one or more of the accused to be discharged with their consent so that they may be witnesses of for the state when, after requiring the prosecution to present evidence and the sworn statement of each proposed state witness at a hearing in support of this charge. 16. Define judgment. Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition of him of the proper penalty of civil liability. If any, it must be written in the official language, personally and directly prepared by the judge and signed by him, and shall contain clearly and distinctly a statement of the facts and the law upon which it is based. Number 17. Define search warrant. A search warrant is an order in writing issued in the name of people of the Philippines, signed by the judge and directed to a peace officer, commanding him to search for personal property described therein to bring it before the court. Number 18. What are the requisites in order that a search warrant be issued? A search warrant shall not issue except upon probable cause in connection with one specific offense to be determined personally by the judge after examination under oath or affirmation of the complainant and a witness he may produce, and of particularly describing the place to be searched and the things to be seized, which may be anywhere in the Philippines. Number 19. What are personal property subject of search and seizure? Personal property to be seized in a search warrant may be issued for the search and seizure of personal property. A. Subject of the offense. B. Stolen and embezzled and other proceeds of the fruits of the offense. Or C. Used or intended to be used as the means of committing an offense. Number 20. What are the qualifications of a witness? Witnesses, their qualification. All person who can perceive and perceiving can make their own perception to the others may be witnesses, religious or political belief, interest in the outcome of the case, or conviction of a crime, unless otherwise provided the law, shall not be ground for disqualification.